Acknowledging traditional owners of the land on which we meet, the Gadigal people of the Eora Nation, and I pay my respect to elders past, present and future. Thank you all for coming today. When Joel asked me to come speak at this event, I thought it was great. It's great to have a bunch of students politically engaging in a range of different issues, and one that's quite provocative, or two issues that are fairly provocative, are refugee rights and the rights of sexual and gender minorities. And so often people think about those two issues in discrete ways, you know, LGBTIQ rights and then refugee rights. And rarely do you see them put into conversation. And for me, when I started working at Amnesty International, I started as an intern doing refugee casework. And one of the really interesting things that I came across was working in that team, a lot of the sexual orientation based claims specifically at that time, and thinking, wow, there's a really rich intersection here between sexual orientation, gender identity-based kind of issues, and issues for asylum seekers who are fleeing persecution and seeking protection in Australia. I guess this is an enormously complicated area of law, policy and practice. So there is no way that I would be able to provide a kind of an overview that you know, is as comprehensive as I would like in the 15 minutes that I have. But I just want to start by looking at the fact that, you know, the Refugee Convention was drafted in 1951 in response to, obviously, a lot of the human rights treaties, specifically the UDHR, Universal Declaration of Human Rights, was drafted post-Second World War, obviously in response to a lot of the atrocities, particularly the genocide of the Jews in Nazi Germany. And basically, this convention was drafted and it was targeted towards people who had kind of experienced persecution during that time, and to offer these people asylum and protection in the countries in which they had fled to. Obviously, there were temporal limits and spatial limits on the convention as it was drafted in 1951, but they changed that in, they removed that with the 1967 protocol, which is now often talked about in tandem with the Refugee Convention. And obviously we've had decades of international human rights law and development. We've had a number of treaties, the Convention on all forms of, on the elimination of all forms of discrimination against women, a similar convention on the elimination of all forms of discrimination against race on race-based grounds. And yet, despite the enormous developments, we still lack any kind of specific governing treaties that address issues facing lesbian, gay, bisexual, transgender, intersex and queer people around the world. In 2007, a bunch of prominent academics and jurists drafted what was called the Yogyakarta Principles, which kind of outlines the current, you know, all the international human rights treaties and laws and customs, and looks at how they apply specifically in situations relating to sexual orientation and gender identity. It's worth emphasising, though, that the Yogyakarta Principles are fairly exclusive of intersex people, with only a few mentions of intersex people and their differences. So for those who don't know, intersex refers to people who have anatomical, chromosomal or hormonal variations that don't make them typically one sex or the other. And so from there, countries around the world obviously continue to persecute sexual minorities and gender minorities with significant amount of force. There are still over 80 countries around the world that criminalise homosexuality. Some countries have the death penalty. And so because people were fleeing on the basis of their sexual orientation and gender identity, they fled to a lot of the kind of Anglophone countries like Canada, the UK, the USA, New Zealand and Australia. And under the Refugee Convention, you can seek asylum on the basis of your race, nationality, political opinion, on the basis of religious grounds, or on the basis of membership to a particular social group. Now, the particular social group is often thought about as the kind of broad, elastic, catch-all category that kind of compensates for a lot of the more prescriptive ones around nationality and race, which are much more narrow in some ways. And so Australia, and this talk will focus specifically on Australia. I would love to talk more about the other countries as well. They've got interesting stories, but for the sake of time, Australia has recognised this as a valid ground of persecution since 1992. And so over the last 2 decades, we've seen a number of claims in this area. So people have sought asylum on the basis of persecution. And what's quite interesting is over the first decade, largely, when these claims were litigated, a lot of the decision makers at that time believed that the particular asylum seeker was gay or lesbian. Their identity wasn't questioned. But what was questioned was their experience of persecution. So what that means is, for example, you had, say, an asylum seeker from China who would claim protection on the basis of persecution. And some of the evidence of his particular persecution in this case in 1999 was that he was arrested after kissing in public with his partner. And so a lot of the cases at that time seemed to suggest that basically, yes, we accept that you're gay or lesbian. Yes, we recognize that that was an experience of harassment, intimidation, but it didn't meet the basis of persecution, the threshold. And they argued that that was effectively because you could be discreet about your sexuality. You could, not kiss in public and avoid the persecution that would result. And it was called it was kind of coined colloquially as the discretion test. So if you were basically living somewhat closeted life, then you could continue living that life and not fear persecution. So you could then be sent back to the country in which you fled. Now, in 2003, the High Court of Australia, over in a 4-3 split decision, basically held that that test was unlawful, and that basically the implication that someone should manage their sexuality in order to avoid persecution could be tantamount to persecution itself. What basically that means is having to hide who you are in itself is an act of persecution. You might not be being, beaten or raped or, otherwise assaulted or harassed, but the fact that you have to live your life in secrecy for fear of these acts could itself amount to persecution. And so that was obviously a landmark decision. It was the first time any superior appellate jurisdiction around the world had recognised this test and had held it to be unlawful and in contradiction to the spirit of the convention and its principles. So obviously it was a landmark decision. But interestingly, there was a shift. So after that decision, administrative decision makers, so kind of bureaucrats who would initially process and screen claims, stopped focusing so much on the persecution, but focused a lot on identity. So you'd have an asylum seeker who would arrive and they would claim they were, say for example, a lesbian from Uganda, and they were seeking protection. And they would ask questions like, can you tell us about the kinds of social groups or clubs that you belong to? Can you tell us about your previous sexual experiences? Can you tell us, about how many times you've, been to a particular club? Basically questions that to authenticate a person's sexual identity through very narrow ways. So basically, how often have you had sex? And, can you tell us about the latest club that you've been to? Obviously, really kind of problematic questions. And so a lot of these claims were dismissed. And so what some academics have called was this shift from discretion, which was focused heavily on the persecution element of an asylum seeker's claim, to disbelief. So it's not that we don't think that, we're not going to focus on your claimed experiences of harassment or violence, but we're actually saying that you're not gay or lesbian, so you actually don't meet the convention criteria for the basis of your persecution. And obviously this has caused enormous challenges. There have been cases since, we had an asylum seeker from Iran who was questioned was asked, can you tell us about Oscar Wilde, Greco-Roman wrestling, Madonna? Now, I'm a very educated gay man, or I'd like to think I am, and I wouldn't be able to tell you about Oscar Wilde or Greco-Roman wrestling. And I did a gender studies degree, so and yet these were the sorts of questions that an asylum seeker from a completely different cultural context was being asked to verify, because those were the kinds of questions that the decision makers thought, well, clearly if you're gay then you know about Madonna. tell us about how often you've had sex, because clearly if you're gay, you must be really promiscuous, so you must have had lots of sexual experiences. And these were the sorts of narratives that were really quite common amongst decision makers. And the trouble is that because the space of refugee law is governed not only by international treaty or domestic legislation, but also regulations, but also because it relies so heavily on discretion, particularly administrative discretion, there is so much inconsistency in this area. There is no real considered training around sexual orientation and gender identity claims with the Department of Immigration and Citizenship. There are no specific sexual orientation and gender identity-based guidelines for decision makers. And so when you read a lot of the decisions, they vary enormously. Some decisions are really well written and have very consistent argumentation. You might read another decision which is much shorter. You cannot even follow the logic of the decision because it jumps from point to point. There's no consistency. So for those of you who know, when you read judicial decisions, for example, there is a sense of, they do obviously vary in size and breadth, but there is a sense of methodology that you can usually follow. Not in all, but mostly. But unfortunately, because administrative decisions are neither precedential, they don't set precedent on other decision makers, nor do they have to abide by a particular format necessarily, or size or length. They can basically have discretion to say whatever they like. It's a one-member panel, usually, that reviews claims that are appealed. And then, unfortunately, the judicial review process is also strictly limited. This is a broader issue. For those of you who follow broader refugee politics and policy in Australia, you'll know that since 1992, we started kind of mandatory detention under the Keating government, and then that was obviously elaborated and expanded under the Howard government. But also during the last decade, there have been numerous attempts to limit the space of judicial review. So basically, whenever you see, a barrister trying to get an injunction against the deportation of asylum seekers, the High Court might come up with a really powerful decision, the importance of procedural fairness. And so the government will respond to this by passing legislation to further limit the grounds of review. So basically, unfortunately, the scope for judges to intervene and to kind of say, actually, this is a really problematic decision is really limited. And so a lot of these cases basically sit in a broader framework of refugee law and policy, but at the same time they also generate their own unique circumstances. When you have an asylum seeker who has had to live their life in secrecy, in silence over their sexual orientation for fear of, going to the police to report violence because they feel they'll be subject to further violence, then a lot of them aren't as forthright when they meet decision makers, and they often delay their claim or delay some of their narrative, and that's often seen as a lack of credibility on their part, rather than seen as a kind of I guess, if you like, a sense of shame, a sexual shame, and a feeling of the need to be secretive about particular aspects of their narrative. And then when you translate this into gender identity claims, so I've talked a lot about sexual orientation, it becomes even more complex. There have been far fewer cases that I'm aware of on gender identity-based grounds. They are, however, recognised as a particular social group, which is great. So, that would vary from, a transsexual person in China or a transgender person in the Philippines. The point of the social group is that it's elastic. So it's not that being, your sexual orientation itself is the social group. It is a specific social group in a specific cultural context usually. So it's usually, homosexual man in China. That is the social group that they use as the basis of making their decision. And that brings its own complexities into it because the social group can be broad or it can be narrow. The benefits of having a broad social group is you can catch more people. Unfortunately, usually it means the specificity of their persecution is often not considered, or their specificity of the violence they're subject to or could be subject to isn't necessarily considered tantamount to the requisite level of persecution. So, I mean, this is obviously a really high-level kind of overview of some of the key issues facing asylum seekers who seek protection on the basis of their sexual orientation and gender identity. I have tried to keep it much more macro in order to give you a broader sense of how this all plays out. There is so much rich material at the minutiae. So if you look at the cases themselves, you'll see, some really provocative questions, and you'll see, some real challenges for people who are, having to navigate between, providing this really coherent script of, oh yeah, I'm really gay. I go to Oxford Street every night, and I party at the Columbian, and here is my partner. Isn't he attractive? And basically, scripting something that you think would work, right, to fit a stereotype. But incidentally, that's often seen as too rehearsed. So people will be like, oh, well, you only came here, and all of a sudden you're now going to these clubs. You're only now sleeping with all these men, if you're a same-sex attracted man. So really, we don't think that you're putting us on. Or alternatively, surplus claims are excluded. So what that means is if you come to Australia and your claim for protection arises after you've left, then that's excluded from consideration under the Migration Act. And so what that means is, even if they do think that you're doing this genuinely, often they might say, well, you've only come here and started doing all these things, and that's what's giving you your claim for protection. So if you go back, you won't be able to do these things, so you'll be fine. So, there's this real double bind in some ways, because this is the challenge ultimately that sits at the heart of a lot of these decisions, is that, on one hand, you're being asked to authenticate your sexuality, right? And in order to do that, you try to pander to stereotypes that you think decision makers want to hear. But at the same time, if you do that, then they think that you're providing a very rehearsed script, that you're basically, telling us what, in their words, what we want to hear in order to gain protection. And, if you look at countries around the world, it's not unique to Australia. These are challenges that are faced by other countries. Obviously, they're limited somewhat by their own national laws and their own national procedures and regulations. But these are the kind of fundamental issues that kind of resonate in different countries when it comes to assessing claims in this area. And that's part of my research at the moment. So I'm about to head overseas to the US and the UK to work with organisations that specialise in this area. And my hope is to be able to kind of see what's working in those countries where they do specialist advocacy and training, and they have a bit more of a developed kind of advocacy and kind of litigation processes, and see how we can improve our systems here in Australia too.